whenever you find lawyers, we are considered and seen as respectable and honorable gentlemen and ladies, or what some of my friends like to say, call gentlemen in skirts, because they always refuse that we have ladies in the profession. But I object. We do have ladies in the profession. Please, can the ladies put their hands together for it? Okay. So, yeah, thank you. So, basically, I'm going to try to round up because I know I have very little time left. So, becoming a lawyer is a voluntary obligation you enter into. It's not, it doesn't happen in a dream. You don't just wake up to become a lawyer. It's a process. So I would like to put in your mind that that process is honorable. And we should always, always keep that in mind and honor it. Now, to the last thematic area, how the law school prepares students for life of practice. How the law school prepares us for life of practice. Now, the law school has a lot of curriculum that allows you to actually experience and prepare for life as a practitioner, as a lawyer. One of those things is what the law school has in place in terms of externship. It gives you a bed view scope of what practice is about. It allows you to go out there and sit down in court with lawyers, right? And after proceedings, you have the opportunity to speak with judges. I remember when I was doing my externship as a student of the Nigerian law school, I actually met with Justice Kani Johnson, one of the most fantastic judges I've met in all my career as a lawyer. And there was a very, very bad case. A very, very bad case. I'm not going to the details of the case, but it was a very, very bad case. And it actually exposed a lot because the case was a murder case. But the defense attorney handled it badly. And when we finished that day, my lord invited us into his office for the first time. And he was livid, you know. Basically because the defense attorney did not really put in any effort to actually do his job, right? And my lord educated us that day that whatever it is, when it comes to practice, when it comes to litigation, the job at the end of the day is about the evidence and the argument. Because the judge was not there. The judge does not know except to bring it before him. The judge is not God. And that's when I understood that there is a very, very big responsibility on our shoulders as lawyers, practicing in law, to ensure that we bring the right evidence, we bring the right document, we bring the right argument to court if we must do our job properly. These are things that will come to mind when your mind begins to form up to practice as a lawyer in Nigeria. Now, another important thing that you must be mindful of as you go to law school, and I want to say that you must participate in, because some people are too serious. It's not on my slide. But some people are too serious about this life. They don't want to do anything again. When you get to law school, please go to the dinner, right? Enjoy it. Go for the cocktail parties. Enjoy it. Do you know why? It is part of what makes you a lawyer. Even when you finish from law school and you become lawyers, you will still attend dinners. You still attend, MBA dinners, luncheons and all of that. These are part of the things that makes you into becoming a proper legal practitioner. Don't say that you are reading one comma somewhere or you are trying to cram law in practice or ethics. No, you must go for those parties, participate, enjoy them. Allow yourself to experience what it is that school is trying to teach you. I hope you guys are getting me. It's very, very important. It's not just about the book. It's also about the practice. And these are the things that encompasses the practice. So please, attend those parties. Attend those dinners. Yes. Okay, so forming professional... Okay, yeah. So the next item I'll be discussing is what we usually like to call the fit and proper rule. Now, everything I've said since the beginning of this conversation is encompassed in what we call the fit and proper rule. You know, remember I said that if you're a lawyer, you're no longer the same person. You have become a different person. You have become someone new, right? So it means that there's something happening to you, whether you like it or not, that makes you consciously and unconsciously into someone else. But that someone else is the lawyer inside you. It's not an identity crisis. It's actually you becoming the professional, you becoming the practitioner. And it's actually what the training does to you. You know, and that is what makes you fit and proper. That's what makes you fit into the shoe of that person that can stand in the gap and advocate, of that person that can actually go to court and make your case on your feet, even when you are met with surprises. That's what makes you that person that can draft that agreement, that can draft that treaty, you know, the laws, the act of parliament, whatever it is. That is what makes you into that public defender that can actually go to court and defend that penniless defendant and not, you know, miscarry his case. Fit and proper. You can no longer just walk anyhow. You cannot just, quote and unquote, as they say in popular palace, do anyhow. Once you become a lawyer, you have entered into the realm of the elite. You must carry yourself with some kind of decorum, respectability. It's not something that you learn. It's something that you become. But then, if you must learn it, because some of us, I remember when I was in school, well, I'll say I just thank God. So if you must learn it, please learn it. Be intentional about it. You know, just build yourself around becoming that practitioner that's going to shape the world. You have to assume that if you don't do it, nobody will do it. You have to assume that it's your responsibility, right? You have that responsibility. Especially in Nigeria right now, you actually have that very urgent responsibility. And it will be very, very good for you to key into that. So yeah, I promise you guys I'll not take your time. And I'm already closing. Basically, what we are doing here is just letting you know that going to law school and coming out successfully, very, very successfully, is doable. It's not an Herculean task. It's all about understanding what you're going to do and understanding how you're going to go about it. I was lucky when I was going to law school, I spoke with a senior who just finished. And he told me one thing, very simple. He said, don't allow it pile up. When you get there, everything you do in a day, read it. The lesson note for the next day, read it before the next day. And then repeat it again the next day. And read the next day's note. And that was what I did. I did not read like I was going to die. But then I read like I meant business. And I just did the needful every day. And it worked for me. Of course, different strokes, different folks. I don't know what works for you. I'm sure by now you know what works for you. The second thing he said to me is that if you went through the university and you passed by yourself, you will pass the law school. And I say the same thing to you. So do not be enamored by any unnecessary worries, because you have actually already started the journey. You have started. You are not just becoming a practitioner. Like I said earlier, you're already equity. You're already a lawyer at equity. So you have started. You are becoming. So the law school is just to put it diadem, to put the crown on all your efforts so that you can be called properly to the bar. On a closing note, I would like to repeat what I said at the beginning of this conversation, which is the fact that, yes, we are translating from students into practitioners, but do not forget, you will always be a student. There is no way to it. There is no end to learning. Knowledge is inexhaustible. You cannot know everything. You cannot stop learning. The day you stop learning, you start what? Who knows? Dying. It's tough, eh? You start dying. That's the truth. The day you stop learning, you start dying. So don't forget, you will always be a student. It's just that this time around, you are becoming a practitioner and a student. I'll go back to my song I started with. The law school basically is just to sign, seal, and deliver you and put you forward to become properly so-called legal practitioners. So it's all about sign, seal, deliver, nothing else. Thank you very much for your time. I wish and I hope that I've been able to address this part of the discourse sufficiently. And if you have any questions, you can quickly put them forward so we can address them before we move to the next section. Thank you. If you also have contributions, you can also make your contributions very briefly so that we can proceed. Okay, so that's one person. I think we can take three. Two. We can take two. Okay. Go ahead, please. Your name and then your question.
My name is Umar Abdulmuin Kayode. So thank you very much, Law Corridor. We are grateful for this opportunity and it's a privilege to be here today. So my question is not really like a question, but I want to seek for a recommendation. Over time, I have attended seminars, workshops, and programs like this. And I've had senior lawyers and even judges say litigation is going into liquidation gradually. And honestly, I don't want to be caught off guard. So please, I want you to sincerely recommend a particular area or few areas in the corporate practice that one can easily venture into. Lucrative ones. Thank you very much.
Please, let's put our hands together for him. Okay, so I will quickly address your question. I'm sure that my colleagues will also address what you've said when they come up. But I'll just quickly address you what you just said. The first thing I want to do is to disabuse your mind on that mentality that liquidation is going to liquidation. I don't know where that's coming from. I can tell you boldly that the soul of practice of law is in litigation. Even in corporate practice, you still come back to litigation. Because disputes are unfathomable. You always have disputes. Now, the truth is there are other forms of dispute resolution. We have arbitration, mediation, all of that. Yes, we have those ones. But litigation cannot be overemphasized. So please, if that is the reason for you thinking about something else, please, that's not a premise. Litigation is still the soul of legal practice. Today, yesterday, tomorrow, forever. The only thing that can happen is there might be some changes in the face of litigation. There might be some kind of changes in the form that litigation takes. But litigation continues. I know, as a matter of fact, that Law Corridor is a very, very active litigation firm, as much as we're also a very, very active corporate firm. So you cannot divide them. You cannot set them aside. Okay, so that's that about that. And with respect to corporate practice, if you choose to go into corporate practice, I would recommend that you sit through this process and you learn. You listen to the other speakers, right? And after all of that, I have no doubt in my mind that you'll be able to form a decision one way or the other, whether you want to go into being an in-house solicitor, or you want to do something else, or you still want to go into litigation. After today's discourse, you have a better opportunity to actually make an informed decision. So I don't want to make that decision for you or recommend anything right now. Is that okay? Okay, thank you. We'll take one more question. Just one more question or comments. Anybody? Okay, so it appears we do not have any other questions. That means I did a good job. All right, gentlemen and ladies, thank you very much for your time. While I was speaking, we had some of our very, very senior partners working and also some of the friends of the firm. So yes, I will be yielding the podium right now so that we can go into the next stage of the discourse. Thank you very much.
One more time, please. A very resounding round of applause for our senior partner, Mr. Franklin Olufemi. Very insightful presentation, and I'm sure that's why there was barely any question to be asked. His job was basically to highlight the transition from the Nigerian law school, or from being a student to being a practitioner. And I'm very pleased with the fact that Mr. Franklin has highlighted the fact that the moment you're currently a lawyer in equity, which means your family and friends have probably been asking you to review something for them. So you've started practicing technically. And with that, the opportunities are abound for you when you're formally called to the bar. You can be a state counsel. You can be an in-house counsel for a blue chip company. You can work in a bank. You can work in an insurance company. You can work in a law firm. You can work as an assistant to a judge, a legal assistant. You can work as a registrar of a court. There's so many things. The word he used is limitless. But what I want to also, take as a pointer from what he said is you must find yourself. Finding yourself is very core. The finding must have started from probably when you were in university. Law school is just to concretize it, putting an icing on the cake for you, because it's like a pipe. You're transitioning from one point to another. So your formation has actually happened in the course of your being in the university. You're just opening a door to enter the new world of being a practitioner through the law school. And we wish you the very best as you do that. One more time, a round of applause for Mr. Franklin. So we'll take the next thematic area, which is the law school curriculum, a synopsis. I would not have to bring anybody here because I'll be doing the honors of that. Mr. Shemilore, please, if my slide is available, could you put that up for us? Now, the law school curriculum is the main thing. I believe that's where your heartbeat comes from. Yeah, you're probably afraid, how do I do it? How do I learn all these things? And you probably must have been hearing from your forerunners that the law school curriculum is broad, is this, is that. We'll simplify all of that for you in just a moment. I believe I also have 35 minutes. I have about 15 minutes to, break down the curriculum for you, and also have 20 minutes to engage questions. I may eat into the 20 minutes for the question, just like Mr. Franklin did, perhaps. If I'm able to clarify things very well, I probably won't be faced with questions like Mr. Franklin also enjoyed. So if we start from that end, we have 3 sub-themes under the thematic area 2, the law school curriculum, a synopsis. The first is to take an analysis of each of the 5 courses taught at the law school. The second is a guide on how best to study each of the course and the significance of each of the courses to being a practitioner. Now, this third sub-theme is going to stream directly into the analysis Mr. Franklin made with regards to the opportunities in the legal profession and transitioning from being a student to being a practitioner. I should quickly say before I dive into this, perhaps for the purpose of those who are here, those who are viewing from everywhere you are in Nigeria, you haven't been posted to the law school yet. There are 6 campuses currently. Are there more? 7, including Port Harcourt now. So those 7 campuses, you don't know where you're going yet. But different things plays out in each of these 5 campuses in terms of how you study and how the system grinds you in the course of study. Lagos is the most, what word should I use? Well, some are using the word best. I wanted to use the most terrifying. That's the word that comes to my own head. Lagos is the most terrifying in terms of how to grind you for the course of study. I usually tell, especially when I just left the law school, I was at the Abuja campus, so I pretty much enjoyed the campus. So I usually tell, and I used to hear things from my friends who are in Lagos. At 8 p.m., they are still doing pre-class. 9 p.m., they are doing pre-class. So I'll just tell any of my friends, when I left the law school, I'll tell anybody, if you know you really, really badly want your first class, go to Lagos campus. If you fairly want first class, like your energy is not really on it. If it comes, fine. If it doesn't come, take Abuja campus. If you really want to enjoy life, like study, chill, both ways, just take Abuja campus, because Abuja will have all the big boys, the senator who want to take law just for fun. So you'll have those people in Abuja campus. But Lagos is a grinder. You clock in. If you miss 75% of your clock in, you're not writing the bar final. You have to know somebody who knows somebody before they will let you write the bar final. Then Kano campus, Yenagua campus. Yenagua campus, if it's rainy season, you swim to take your lecture, you swim back. So all of those things affect how you study these courses. I'm just giving you guys insight into these things. Then Port Harcourt campus is the newest campus. That's Wike campus, chilling with hostel and all those fresh things. So if you want the soft life and you want to also be eating bole every time, take Port Harcourt campus. So, well, it's not like you have the opportunity to take. If they post you there, you're lucky. You take it. But if you have someone who knows someone who can put you in Abuja campus, why not? Go for it. Now, let's dive into the analysis of each of the 5 courses. You're going to study 5 courses at the law school. The first is civil litigation. No, this is not in any particular order. I just put this here in my own way of numbering. Civil litigation, criminal litigation, property law, corporate law, and professional ethics. Now, there's something about how these courses come, which automatically flows into the next slide, right? So I'd like to have the next slide so I can link the 2 together. Now, the next slide tells us that there's something about residual knowledge on guide on how to best study the courses. This guide is basically because your first thing coming from residual knowledge is that what you're learning in law school is a flow from what you've learned in the university in a way. And your university also plays a pivotal role on how you find the law school program. I'll explain. Now, you have core courses in the university. Oh, you had. You guys have left the university now. So you had core courses and you had elective courses at the university. Your core courses, apparently, let's say at 200 level, will be law of contract, Nigerian legal system, and constitutional law. Then you have elective. Your elective could be Islamic law, could be fundamental human rights. All of this depends on your university, actually. Then at 300 level, you have a core course. Criminal law must be a core. Taxation, no, is it? Commercial law must be a core. And the third is law of torts. Those 3 are your core courses for 300 level in every university. Your elective depends on your university. For 400 level, Nigerian land law is a core. Law of evidence is a core. Equity and trust is a core, right? In all universities, whether private, whether public, it doesn't matter. But your elective depends on your school. At 500 level, you must study company law, right? As a core. You must study jurisprudence as a core. Then the rest of the 2 courses, also elective, all depends on you and your university. Now, these core courses form a very solid foundation for what you're learning at the law school. Now, at the university, you could have taken criminal procedure as an elective. You may not have. You may have taken civil procedure as an elective. You may not have. You may have taken legal drafting and conveyancing as an elective. You may not have. You may have taken what other course? There's so many other electives, basically. But these three I mentioned, they are connected to what is being taught at the law school. You may have also taken legal practice as an elective. And for schools and university and law faculties that have law clinic, legal practice becomes very essential for what you'll be learning as professional ethics when you get to the law school. Now, you see why I tagged residual knowledge as one of the guides on how to study, because your residual knowledge forms the foundation for what you're learning and how you're learning in the law school. Now, if during your university days you are taking as an elective, no, first, as a core, you've taken land law as a core course, you've taken equity and trust as a core course, then you took legislative drafting, conveyancing and legislative drafting as an elective. If you've taken that as an elective, put these three together, they will form a very good recipe, perfect recipe for your learning of property law, which is one of the courses. These three will be a perfect recipe, right? I just mentioned recipe before we go into the cooking. I'd like to acknowledge the presence of the managing partner of Law Corridor, who just walked in, Mr. Henry Kelechuku Eniotu. Please, a round of applause for him. Thank you, Mr. Henry, for joining us. Now, back to the cooking. If during your university days you took civil procedure, you took Nigerian legal system in 200 level, and took civil procedure as an elective at 400 level, these two, and then constitutional law, these three at 200 level. These three forms a perfect recipe for your learning of civil litigation at the law school. Then again, at 500 level, you did corporate law as a core, right? At 300 level, you did commercial law as a core. Then 200 level, you did contract. These three form a perfect combo of corporate practice at law school. Then if at 400 level, you did legal practice, and maybe 500 level, and you were a clinician, and you perhaps participated in moot and mock. Same for criminal litigation, same for civil litigation. They form a perfect recipe for professional ethics. Then in addition, for criminal litigation, if you've apparently studied criminal law in 300 level, then you studied as an elective criminal procedure at 400, and then, of course, if you participated in legal practice, you're a clinician, then you also participated in moot and mock. You have a perfect recipe for cooking your criminal litigation. So you see why your residual knowledge forms a very solid foundation for how you study the 5 courses being taught at the law school. Now, assuming you missed out on any of those things, those electives that I mentioned, apparently there's no way you would have missed out on the core. There's no way you'd be at the law school. The things you can miss out are the elective. You probably didn't take civil procedure, you didn't take criminal procedure, you didn't take legal drafting and conveyancing, you didn't take legal practice, you were not participating in the moot and mock trial, you are not an advocate, you are not a judge, you are not a registrar, you're nothing. You just were basically a student at the faculty, going to class, going to the library, going home. Nothing more. Then it means you have a dent with the residual knowledge that needs to be quickly polished at the very beginning of your program. Now, law school will start teaching you these 5 courses: civil, criminal, corporate, property, and professional ethics, with the mindset that you had already learned the substantive things and law while you were at the university. They will never start teaching you the Land Use Act at the law school. They won't do that. That chapter had been closed while you were at the university. So if there's anything you missed out learning in land law, as you're about to start your law school program, you need a quick brush up. You need to quickly do a brush up. If you didn't study legal drafting and conveyancing, it's not that bad, because what the entire property law is about is drafting property transactions, drafting documents and conducting property transactions. Now, why conveyancing would have been very essential for you, legal drafting and conveyancing as a combined course, is because you learn the rules of drafting first, then you learn the conveyance next. So basically, you're learning all the rules of drafting first in your first semester, and then in your second semester, you're now learning the deeds, deed of assignment, deed of lease, and the rest of them in your second semester. So by the time you get to law school, that second aspect of your curriculum in conveyancing and legal drafting is what you're actually learning at the law school. So it's like a revised learning, so to say. Some of my peers, when we went to law school together, that we did conveyancing, it was a bonus. We practically didn't drop any sweat learning property law in law school. Not a sweat. Everything was just like a refresher for us. All right? So you need to quickly do a brush up on residual knowledge. Your constitution, pick it up. Brush yourself up on the constitution. Understanding all the essential aspects of the constitution, chapter by chapter. Your chapter 4 will be essential when you're learning civil litigation. It will be essential when you're learning criminal litigation. Your chapter 7, where courts are structured, they will be essential for you in criminal, they will be essential for you in civil, because you have to first know the jurisdiction of all the courts. Do you understand? So you have to quickly do a brush up on the residual knowledge. So this is a leap. So let me quickly go back to the 5 courses. Your civil litigation is basically to enlighten you on how you conduct civil cases from beginning to the end, especially at trial level. Because now your law school curriculum is based on the number of weeks you're to spend at the law school. And I don't know if the law school, I think in the last 1 or 2 years, I learned they haven't been giving the law school handbook to students. I don't know if they have a new one. I learned they're working on a new one. I don't know if it's ready. If your set is going to be lucky to have a copy of law school handbook. Now, the law school handbook used to be, from what used to happen, what used to be available in the past ones available, they structure it based on weeks. So your week 1 and 2, I think they are resumption, induction, and then your lecture starts from week 3. So your topics are broken down into weeks, and they are sequentially arranged. When I say sequentially, they are arranged in the order of importance based on that topic. So take civil litigation, for instance. In your week 3, you're basically to learn about jurisdiction, Nigerian courts with civil jurisdiction, basically, from the magistrate court to the area court to Sharia court to the High Court to the Sharia Court of Appeal, whatever, all of those courts, up to the Supreme Court. So your learning of the hierarchy of court and legal system back then, and what you must have studied in Chapter 7 of the Constitution becomes very essential. Knowing what matters go to what courts becomes very vital. So you see where your residual knowledge comes to play. Now, you're following that because if you want to initiate an action in court, the first thing to do is to know what court you're going to. Am I even going for arbitration, mediation, before I even decide I'm going to court? What are the clogs preventing you from going to court? All of those things, you learn them in your week 3, I think. Then your week 4, who can go to court? Parties. you first ask yourself, which court am I going to? Then the next question, who am I taking to court and who is going to court? Parties. Then the next question, if I'm to go to the magistrate court, what are the preliminary things I should take into cognizance? If I'm commencing the action at the high court, what are the things I should take into cognizance, right? What are the applications I should make ahead of time or in the course of trial? That's interim or interlocutory. You learn that around week 7. By your week 8, you're learning, I think week 8 and 9, pleadings. What are the documents I will file, front load? Your pleadings. Your week 10, your pretrial conference. Your week 11, 12, 13, your trial. Your week 14, judgment, final address, all those things. Judgment, then appeal, week 16. Your week 17, you're already learning recovery of premises. Your week 18, election petition. Week 19, matrimonial causes. Week 20, fundamental rights. And that's the end of your civil litigation. So you see how I called the snapshot of your courses? Right? So your week 3 to 20, I just read it out for you in about 2 minutes. And that's how it plays out in every course. Your criminal litigation, the same thing. Your property law, the same thing. So they sequence what you need to learn in the order of importance. For your criminal litigation, you will also start by learning jurisdiction, right? Before you talk about who even has criminal jurisdiction, who can prosecute. After you talk about the courts with criminal jurisdiction, you move into the persons that can prosecute, the police, the EFCC, their powers and all of that. Then how do they commence prosecution? Arresting, searching, all of those things will follow. Then what are the rights of citizens that must be taken into cognizance in the course of all that arrest, search, and all of that? So your fundamental rights comes into play. If you've done all of that and you're good to go to court, how do you prepare the charge? When you have the charge, how do you arraign? Trial, judgment, appeal. That sequence as well for your criminal, right? So your handbook naturally will have a flow of your topics in this order, all right? The same thing applies for your property law. Your property law is basically property transactions, right? So like I mentioned, the idea that you've learned land law in university, but property transaction goes beyond merely the landed transaction, apparently, because you have to consider contract of sale, you consider an assignment, you consider mortgage, you consider lease, then appointing someone to carry on anything in relation to your property, appointing an attorney. All right? So all of these are also sequentially arranged for you to learn. What you best do for yourself is to simplify them in this sequence, the way I just said it, and asking yourself all the relevant questions about each of the sequence. Once you're able to sequence the topic and understand how one flow into the other, then it becomes naturally easy for you. And like I always say, I don't advise anyone to go to law school to cram. It's not in my diary. The first thing you should learn to do is to understand something. Once you understand it, it becomes naturally a part of you. Once it's naturally a part of you, you can easily recall it. You can easily talk about it. You can easily write about it. And that's what you do in the exam hall. Do you understand? So this flows for all the topics. The only topics that seem far-fetched for me in terms of sequence is corporate practice. And I say that because this is not to disturb your mind. There's been of late some sort of distance between the reality in corporate practice and what is being taught at the law school. So basically, your learning of corporate practice will depend on what the curriculum looks like in a particular year, in view of the changes that naturally would happen within the corporate world. Maybe 5-6 years ago, your curriculum would naturally start with, if you're going to register a company, what are the instructions you should take from anyone who wants to register a company? Your ability to understand the various types of companies that carry on practice in the business world, either as a partnership, as like a business name which can come under the umbrella of partnership or a sole proprietorship, both of them coming under the auspices of business name, either a private company limited by shares, a private company limited by guarantee, or a public company, or an unlimited company. All of these categories, there are usually about 6 of them. But with the passage of CAMA 2020, there are wider options. Limited liability partnership is there, limited partnership is now there. So there's so many things that have evolved over the years or in recent years on corporate practice, which would require you to first understand the curriculum, see the merger, because sometimes you probably, for those who are going to law, who have been either interning at a law firm before they're going into the law school, you may find that certain things that you've learned while you're in the law firm in terms of corporate practice will be a little bit detached from what you find at the law school, okay? That's basically because evolution is occurring in the practice world. Post-incorporation and all these things. These days, we don't feel, you don't do Form CAC 1A again, you know, to even reserve name. You don't fill any form to reserve name anymore. You don't even fill forms, basically, to even register a company anymore, in the real sense of it. So, but back then, we would have a form that would be attached to maybe your exam question. They ask you to fill in where the shareholders are and all of those things. But some underlying details on corporate practice are still available, and they will still form your core curriculum. Understanding the essence of distinguishing between an individual as an entity and the corporation as its own entity. Understanding the rules relating to your memorandum of association, your object clause, your name clause, all of those are still exactly as they are from time immemorial. They've not changed. So all those common law principles regulating name of a company and issues arising from using the name, you know, of a name that already exists and all those things, and then shareholding, the object clause, all of those are still relevant, and they're still going to be functional as far as your curriculum is concerned. Then you now stream into the big deals, the merger, the corporate restructuring, internal, external, liquidation, winding up, and all of those. They are still essential. Those ones have not changed, and they form a core path of your curriculum. Foreign participation, a Nigerian stake in business, a foreigner stake in a Nigerian business, all of those, the rules are still there. And so those are the things that form your curriculum. So it's a broader narrative of what you learned in your 500 level as a corporate law student. So you must have learned about director, secretary, corporate personality in the university, but you're learning them at a grand scale now in law school, in more practical form. So if you want to carry out a merger, what are the steps to take? If you want to carry out acquisition, what are the steps to take? If you want to change the name of a company, what are the steps to take? If you want to increase your share capital, if you want to change your object clause, what are the things you do? So they're basically procedural now, and that's why what you've learned in the law school and the university is going to be slightly different or more advanced in terms of corporate practice, and they still form your curriculum nonetheless. Okay? So, and I know students are always complaining, corporate is the broadest. There's this tagging students have at the law school about which course is broad. Then some will say it's civil. You have to, so they have different characteristics. So for your civil litigation, the combination of things you need to learn are a bit much, so to say. You have to know cases on procedural issues, service, for instance, or the, what's this shipping company case on issue of service, MV something on shipping, or the Mark AK and the likes on service. So you must know case laws on each of the principles for civil litigation, for instance. Then you know the rules of court. Then you now know statutes establishing courts. Then you now know how to draft processes. You draft motions, draft applications, draft pleadings, that statement of claim, statement of defense. So I think because of all these, bits and pieces, some students used to have apprehension for civil litigation as being the most burdensome. Some will be like, no, I'm fine with civil. Corporate has a problem because you have to learn a lot of procedure. Then you realize, by the time you get into law school, you realize that you guys will come into groupings to give codings to procedure, acronyms on procedure. So if there are 5 steps, you put acronym to it, and you people start cramming. One way or the other, it will start happening. Do you understand? So in terms of which course is burdensome, some will tilt towards corporate, some will tilt towards civil litigation. But in my opinion, like I said about foundational knowledge or residual knowledge, once you're comfortable knowing all the rules relating to jurisdiction, parties, and the rest, it becomes lighter. The burden becomes pretty much lighter for you. It becomes lighter. I think about maybe 6-7 years ago, I wrote 25 reasons why you should participate in the moot and mock trial of your school. I don't know how far that write-up went, but I wrote 25 reasons. Of course, one of it is because you avoid stage fright, your residual knowledge will widen, you'll be able to take advantage of having learned criminal litigation and civil litigation, which will be taught at the law school ahead of time. So I'm repeating that now, but I mean, you're already out of the school. For those who didn't participate, you can't go back, but you can make it up. Just read ahead, okay? So those are the 5 courses. I hope I did a good breakdown for them. If there are any questions, you can always ask. Now, back to the guideline. I said I was taking 2 slides together. I've already explained why residual knowledge is very essential on how to study your courses. I believe that should be perfectly understood. They serve as a foundation for what you're going to study at the law school, and what you learn in university is still pretty much relevant. I've given ample examples of that. Now, the next guide is using textbook. I put this here because as a student, or during my days as a student, I know that at the beginning of the session, my law library used to be very empty. If the school resumes, and 4 weeks into resumption, you go to the law library, you barely see anyone. Maybe like 5-6 students will be there in the library. The problematic ones, they'll be the ones in the library. The real students, they'll be enjoying themselves, vibing, going to the hostel, chilling, right? Now, why I said that is because law school also has library. And I can bet you students are always very rare to find there too. But because they have nowhere else to go, you find more students in the law library of the law school than in the university. The textbooks there may not be particularly useful for you, but I put textbook here for one particular reason. When you go to law school, you'll be exposed to several things. Material, simplified material, easy read, this one, that one. Something to just give you the impression that if you read that book, you're wasting your time. Or there's a shortcut to knowing what you are supposed to know. I mean, I commend those people who do those easy read things. I mean, it's not to demean them. There are people who need it genuinely. But at the same time, if you want to excel, like you want to distinguish yourself, you need to go through textbooks. You need to read textbooks. For 2 reasons I put here. There may be more, but there are more. There are just 2 I put here. I said, textbook ensure it. No, first you have to ensure it's a current edition, because those things you find in those easy read, they may be old knowledge. There may be new rules. There may be, and the person who would hand them to you may not know that they need to give you the circumspection that this is no longer relevant. Or while some things in that easy read may be relevant, some are no longer relevant, but they will give you anyway, and then you swallow everything hook, line, and sinker. It's dangerous. But if you pick a textbook and you find out first whether that textbook is the current edition, when I say current edition, let's take, for instance, you're reading a book on civil procedure, and Lagos State currently operates the 2019 Lagos State High Court Civil Procedure Rules, while Abuja operates 2025, right? And a book is published in 2020, which means that textbook would have the relevant provisions of the Lagos State High Court Civil Procedure Rules, but not the relevant provision of the Abuja High Court Civil Procedure Rules. Do you understand? Because it was published in 2020. Which means if you're buying a textbook or you want to read a textbook, you should read the one published post-2025. Or circumspection. If someone gifts you a book which was published in 2023, 2024, 2020, which is pre-2025 High Court Rules of Abuja, you pick up that book and read it with circumspection, which means anywhere you see the High Court Rules of Abuja being referred to, you would not work with that in the textbook. You go to the Rules of Court of 2025 and find out the relevant provision to be sure if what is in that textbook is still the correct version, or if the correct version is not in that textbook. That way, you're able to sift out the no longer extant provisions in that book while you're working with the relevant provision and saving yourself some 10,000 naira anyway. Do you understand? Because the book, the newly published book may be 10,000, and then your brother has just gifted you the one he used 2 years ago. And the only difference in that book, perhaps, I say perhaps because there may be case laws too that have changed and that are of very, very serious significance that you can't live by the old authorities. You understand? So that's the essence of why textbooks are relevant. Textbooks also give elaborate explanation on issues which you would not see in easy read. And when you're done with law school, remember Mr. Franklin taught you or discussed with you transitioning from being a student to a practitioner. When you're done with the easy read and you crammed just that line that made the reading easy, you now get to the courtroom where it's not longer going to be easy, where that single line is not what you're going to use, where you're faced with a novel scenario that requires you to understand the foundation or the essence of what is at stake. Navigating your way out of that situation will be how you have studied elaborately through textbooks, which the easy read won't do for you. That's the honest truth. So that's why I put this to. They provide more details for broader knowledge and understanding, way beyond cramming. All right? So, but if you start early, if you don't pile up, I mean, that's the word you used. You said don't pile up. If you don't pile up, for every day you need to understand something, you read it in a textbook and you understood it, then you now use the easy read as reminders or nuggets. Do you understand? Then you're good to go. The third thing is statute and case laws. I've invariably spoken about this along the way. Your textbooks are as important as your statute and case laws, vice versa. Statute and case law, you have to know which ones are the relevant and the extant ones. You can't be reading a statute that is dead and gone and no longer in force. Then they also make the difference between grades. If you are going to attend Abuja campus, you might, I don't know if Mr. Olowononi is still in Abuja campus, you might come across a lecturer called Olowononi. Olowononi will tell you, Mr. Olowononi will tell you, if you ask a question and a student stands up and answers, you say, oh, that's a 2-1 answer. If somebody else answers, no, that's a 2-2 answer. If another person answers, no, that's a first-class answer. The reason why he's changing the grade between the people answering is based on how they merge authority with what they're saying. So if you say, by virtue of section 36, sub 6C, every person suspected of committing a crime shall be entitled to representation by a legal practitioner of his choice. Hence, the denial of blah, blah, blah to see his lawyer is unconstitutional. You say, oh, first class. Do you understand? So how you answer, it depends on your use of case law and statutes, because they make a difference between those who have first class, those who will have, that's aside from the marking scheme, marking pattern, because somebody who has, in my opinion, 4 A's and 1 B should also be a first class, in my opinion. So that's not to talk about the grading system. It's just basically in terms of your scores. Then, secondly, they help deepen appreciation of the law, and they are the true test of being a lawyer. I think far back as 2018, I wrote somewhere that if you go to a news vendor stand, you see people arguing about political issues, about what Wike did, what El-Rufai did, what someone said somewhere. But if you stand there and listen, none of those people at the newspaper stand will be talking law. They'll basically be talking politics, right? But as a lawyer, you will only distinguish yourself when you say, oh, what this person did is against this provision of this law. The court has said this in this place and this place, that if you do this, this is the outcome. When you add the case law and statute to it, it makes a distinction of you being a lawyer and then being a mere newspaper stand commentator. All right? So please, these are my highlights for guides. There are more. Perhaps when you ask questions, I may be able to answer specifically. These are the guides to how you study the 5 courses. The third part of my conversation is supposed to be how the courses are relevant to your transitioning from law school, from being a student to a practitioner. Mr. Franklin has said something about your transitioning earlier, but if I'm going to add to that, specifically in view of the 5 courses in terms of practice. So let's take, for instance, at the law school, back to our residual knowledge again, you are taking inclination towards your civil procedure, your constitutional law, Nigerian legal system, legal practice, and you put all of this together, and you already have in mind that you want to be a litigation lawyer. You're on the right path. You've already done your culmination. Now, in law school, there's no specialization in law school. You must pass all 5 courses with good grades for you to enter the profession anyway. So whether you want to specialize or you don't want to specialize, it matters not at the law school. It will affect your grade, apparently, but it does not matter your specialization. You have to pass all 5 courses. After all, you must have been taught since way back 100 level that in Nigerian legal practice, there is no separation between solicitor and advocate. When you are called as a barrister and solicitor of the Supreme Court of Nigeria. So there's no separation. You must, whether you want to go into corporate practice or you want to go into litigation, advocate, you want to be a registrar of a court, you want to work in a bank, you want to be an advisor, a corporate advisor, financial firm advisor, whatever it is you want to do. As far as law school is concerned, just write your exam, have your good grades in all your 5 courses, have your first class, 2-1, 2-2, whatever suits or rocks your boat, get it, and then you move into your specialized world. So I always advise that your specialization doesn't happen at the law school. It must have happened first at your university. When you were in your maritime law class, did you like it? When you were studying property law in university, did you like it? Did it catch your interest? IP, did it catch your interest? So it's not law school that frames you into what you would become in practice per se. It is only a concretization of what has been your background, right? But if you apparently want to be in the corporate world, just increase your learning, your corporate law, as the way they will teach you in law school. Add it to what you've learned at the university under your company law. Add your knowledge of your law of contract to it. So all those things that forms your residual and commercial law, they automatically transition into how you become a very good corporate lawyer. Then, of course, if you've participated in moot and mock trial, do the same thing at the law school. Complement your learning with criminal litigation, civil litigation. Join them, be a counsel as part of a judge or whatever in the moot and mock trial at the law school. When you go for externship again, participate in activities of the firm. Go to court with them. Contribute to issues and things that will happen during the law training that you'll have at the law firm. That will also cement your transitioning from being a student into a proper advocate, right? If you want to become a text author, I mean, you've already done your legal drafting in school. You know the rules of draft. If you want to be a research assistant to a judge, it means you're already good with researching at the university. We won't all be at the forefront. I don't know if there's anybody who has seen the movie of Ronan J. Denzel Washington. He was in a law firm, and he wasn't going to court. He was just drafting processes, and they were winning cases. He didn't go to argue in the open as an advocate. Do you understand? So that's how the transition happens from your university into the law school and into the practice. I think with that, I should open the floor for questions and then wrap my session up. Thank you very much. So, any question, anyone? Do you have any questions from anyone online as well, Mr. Sam? Can we track those who are online with us if they have questions? You know you can't be shy as law school students, right? They'll pass the mic around, and then they'll ask you to say something when they finish. So, Mr. Franklin, please do me the honors of, let's just do a rehearsal of what happens in law school. Lagos campus, you know how it happens. You just move your hand like this. The mic will keep passing, then it will stop. Pass it. Let's try it. Pass the mic. Keep passing it. Keep passing it. Yes, you. So as it's in between two of you, you push it, you push it back, say no, it's you. So then I'll now say no, the lady in white. Then you now stand up and comment. So let's hear your comments. Let's have you say something concerning the 5 courses. Can you kindly just introduce yourself?
Okay, good morning, everyone. My name is Idara Basi. I'm an aspirant to the Nigerian bar.
Yes, you're an aspirant to the Nigerian bar. Not Ilda Basi, aspirant to the Nigerian bar, please.
So I didn't get a question. I should comment on the 5
You
courses.
can comment on any of the 5 courses. You ask any question if you so desire to.
I don't have any questions.
Okay.
But I would say that civil litigation, criminal litigation, and all the courses that have been said, they are bulky and all that, I genuinely just look forward to understanding them and making the best time of my stay in law school.
All right, that's great.
Thank you.
You pass it backward to the gentleman in suit.
It's been an insightful session. I've been able to garner a lot of knowledge, and to emphasize again on what you spoke about, the importance of residual knowledge, it cannot be overemphasized, because from what I've heard, what we're taught in uni is substantive law, but at the Nigerian law school, we tend to be exposed to the procedural aspect of this substantive law. So having a strong background of residual knowledge, which you spoke about, would actually help and upskill in Nigerian law school. The examples you gave of having background in land law, commercial law, contract would help in property law practice, criminal law, evidence, and the likes will help in criminal litigation. So the importance of residual knowledge cannot be overemphasized. So thank you.
That's excellent. All right, so I think with this, my session is up. I would now, we'll go to the 3rd thematic area. Oh, a question?
Good afternoon, everyone. My name is Nasir Yahya. I'm also a law school aspirant. Actually, I've already gotten my admission. We're just waiting for the posting. My question goes like this. University, there's a way you grade your scores and see if you can finish with the first class, second class, and the rest. So in law school, I heard that you're going to take 5 courses, and then you have to pass all. Because I think I saw someone result which has almost A, all A, and then the last course was, is it E or F? And then they told me that person has failed, which was, I'm so curious, seriously. So please, I want you to help and then break it down and tell us how to score our grade and then see how to pass. Thank you.
Excellent question. What this young man just raised now, 2018 when I published the textbook titled Modern Nigerian Legal System, I think in chapter 10, I dedicated that chapter to legal education in Nigeria. And in one of the pages, I can't remember the exact page, I addressed the need for the Nigerian Law School to take a second look at the grading system at the Nigerian Law School. Because, in my opinion, it seemed inequitable. That's a word in my mind. Why do I say so? You rightly point, your example is true to its core. If you have 5 A's and 4 A's and 1 E, I don't even think you're allowed to even have F in law school. I'm not sure. If you have 4 A's and 1 E, you're passing by your lowest grade. That's how it's described. You passed by your lowest grade. So your 4 A's are technically almost insignificant if you don't have the 5th A. So if you have 4 A's and 1 B, you have a B plus. There's B plus and B. If you have 4 A's and 1 B plus, you have 2-1. That's second class upper. If you have 4 A's and just regular B, you have 2-2. That's second class lower. If you have 5 A's, you have first class. If you have 4 A's and 1 C, it's pass. It's pass. Then if you have maybe 3 B's and 2 C's, then your cumulative score is around something. Then you now fail 1. No, if you have 3 B's, 1 C, then you fail 1, they call it conditional pass. Conditional in the sense that you're coming back to write. Kamar, that's wrong.
If you have F in any of the courses, you're coming back to write all 5. Even if you have 4 exams. You're coming to write all 5. Ethics, right? Okay.
So that's what I'm saying.
Thank you very much, everyone. There's another point that we didn't talk about grading. In the law school, there is a new system that is introduced. You can't have all E's and pass. You still come back to write all the courses. There is a percentage that you must scale above before you can pass. You can't have C, C, E, 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 and expect to be called to bar. So they won't tell you that until you ask. Oh, I didn't have it, I just know by knowledge.
Thank you for that contribution. I was getting to that. It was because Mr. Kamara wanted to give me a highlight of where the F's come from. I know if you have 1 F and you have 4 B's, 4 A's, you have conditional pass. You're coming back to write just 1 course. But if, based on your grading, you have scattered grades of A, B, D, C, and then your cumulative score falls below 250, I think, you fail. You go back and write all courses. Or if you have 2F, then 1A, 2B, you have 2F, is also fail. You go back and write all courses. Now, the sad path is you will never be told this on paper. It's part of the things I wrote in the textbook. I critiqued it, that it's bad that you're not even told how you're even going to pass. It's a mystery. And that's bad. It's bad. You don't get to know. And what's even worse is when you finish writing, they tell you you've passed, either with the second class or they don't tell you your grade. You have to pay to know the breakdown of your result. You have to, so if you've written and you have a 2-1, how did I get this 2-1? Where did I go wrong? To know where you went wrong, you pay. When you pay, they'll now give you the breakdown. You now check and see that, oh, it's property law that gave me B+. If not, I would have been a first-class student. Now, I recommended, because I don't like to look at a problem without recommendations, so I recommended that because law school doesn't want to do CGP and grade point pattern, they can adopt it in 2 semesters, break the exam down into 2 semesters, break the law school program down into 2 semesters, write in first semester, write in second semester, and do accumulation. So if they accumulate your grades from first, because anything could have happened to you in your first semester. You may have fallen ill. It may be you've written 3 exams, you were really ready for all 5. And somehow you had malaria fever. It affected how you performed in the exam hall for your 5th paper. And you couldn't do well. Not because you don't know, but because you don't have the wherewithal to do the writing. And if you've written 3 or 4 papers, you can't say you want to defer again. No. You must die in that hall. So all of this makes, your apprehension very genuine. And perhaps we're using this opportunity once again to call on the authorities to take a second look probably with the new DG they have, Nigerian Bar Association, but nobody seemed to care. That's the sad part of it. Nobody seemed to care. When I wrote the recommendation I did in 2018, I sent it to the deputy, DDG of the Abuja campus then, one of the deputy directors at the Abuja campus then that I know was heading civil litigation. I sent it to her that I think the system needs to take a second look at what they do with grading. You understand? Maybe with time, if I'm able to get through one of the DGs, hopefully we'll have it changed, But your generation is lucky. From 2010, there's been more, from 2017 to now, there's been more first class. The number of first class have increased, so which means they are less. I don't know whether I say they are less stringent in marking. I don't know. I don't know what happened. But before 2017, there used to be like maybe 5, 7, 10 first class. But then, after from 2017 upwards, start having 50, 100 first class. So, the net is wider now. And if you put your acts together, just go all in. Say, I'm going to have my 5 A's, and that's first class. Then they say if you aim for the moon and fall, you fall among the stars. Yeah, so 2-1 is ready to receive you. Is it good? Have I answered your question? Thank you. So, in the absence of any further questions on the thematic area I just discussed, we'll proceed to the 3rd clarification now.
Yeah, just a little clarification on something. When the deputy managing partner was talking, he mentioned that when you have an issue with law school with respect to your results, for you to know what you get, you have to pay. So please, let's make this clarification. You are not paying law school to sort anybody.
Thank you.
You make application for your transcript and breakdown of your result, and you are going to pay prescribed fee for that purpose, official prescribed fee, and you will be given.
Thank you very much, Mr. Sunday. Very, very necessary clarification. You make application for breakdown of your results. Then transcript is also different. For those who are applying to JAPA, you pay for transcript. They are going to send it to Canada and all of that. You apply and then pay. Anyway, but my point still remains that it's not equitable that you should have to apply and make payment to see the breakdown of your results. Throughout your university days, once you write your exam, they'll either send it to your portal for you to see what you scored in legal system, company law. So why should civil litigation be different? Why can't I see what I scored on the portal of Nigerian Law School, what I scored in corporate law and civil? Why must I apply for it? I'm still back to that same position. So thank you very much once again, Mr. Sunday, for that clarification. And now let's bring on the elephant in the room to discuss with us the elephant topic in the room. Now, what we want to do with the 3rd thematic areas because this journey will end with something called the bar final, right? We decided to add the word ultimate to it because over time, there's been several apprehensions about the bar final. We hope to demystify that thagging, and to do that, we have the honors of inviting the Managing Partner Law Corridor, Mr. Henry Kelechukwu. Please, a round of applause for him.
Good afternoon, everyone. I must say that even before I came in, I was following the program, and I listened to Mr. Franklin speak, and equally Mr. Jibola. I'm sure our time here has been quite rewarding, very, very rewarding for all participants. I equally listened to your question while I was still on my way here. What's your name, please? Omar, yeah, thank you. I will respond to that your question because your question was a question of great notes and needs to be corrected very clearly. The thematic here is basically the ultimate bar final. When I saw that title, I had a problem with it because I don't think there's anything called the ultimate bar final. It is, for me, the bar final. The word ultimate is actually, for me, what brings the fear, the apprehension, the tension, and the entire trauma which students of the bar law school pass through when they go to their various campuses. Everyone in this place and those participating online, I'm sure, have written multiple exams. Multiple exams. For every exam, surely there are instructions, there are rules and regulations governing every exams. However, the one thing that resonates amongst all of them is simply the fact that if you are prepared for the exam is there to be taken. Very simple. It is only when you are short of ideas that the issue of ultimate now becomes a problem. I recall when Mr. Jibola was speaking, he spoke about the various campuses, Lagos, Port Harcourt, Abuja, and what different people think about it. For me, too, I believe it's a question of mentality. You can be in any campus and make any result you want to make. The campus you belong to does not determine your results. What determines your result is your personal conviction and the personal attempt and efforts to make that particular result. When we were still in law school, I remember then we didn't have the Port Harcourt campus, and we had Yola, we had Enugu, etc. These various campuses, they have their various style of lecturing and various style of operation. I think in Yola then, they used to close or shut school by 2. 1, thank you. By reason of the weather and some other things. Enugu had their peculiarity, Bayelsa had their peculiarity. Kano, where I was, had our own peculiarity. Lagos, their own peculiarity. Abuja, their peculiarity. But the singular thing in common to everyone was this: curriculum of the law school is one and the same. The only difference is the lecturers at the various campuses may lecture in the way they believe is the best way for them to communicate with the students in those campuses. Hence, it's usually very important that when you go to the law school, try as much as possible. What works for every individual here may not be the same that may work for another person. We all here, as many as we are here, and our faces are all different, our suits and apparels looking different. So are our styles of learning. No one stroke works for everybody. None at all. Hence, don't be deceived when you meet people who say, if you don't read for 10 hours a day, you're failing. It is not true. If you don't go and meet one lecturer to understand what he is saying, you will fail. That is not true. One thing I must also correct is this perception. You know, Mr. Jibola did say something, and I agree with him totally on that. What distinguishes an excellent student with a very good student is more knowledge and understanding. He gave 3 outlines here when he talked about residual, textbooks, case laws, and statutes. What he spoke about, textbooks, resonates with me very more. The reason why I say this is very clear. When you get to the law school, I don't know, depending on the various campuses, I think when we were in Kano then, I don't know his rank now, Dr. Obi Okoye led a team of other lecturers, and they came into the hostels to seize pamphlets and external materials. That, for me, was, to my mind, a good decision. Because law school is law school. The marking scheme is determined by the lecturers, not by the authors of textbooks you buy in the markets, and not by those persons who are tutors, who try to help you understand. Those are not the ones who determine the marking scheme. The marking scheme is an internally generated system determined by the internal lecturers of the law school. So what you must get to understand is that the most important person or the most important source of knowledge in the law school are your lectures. You know, the speed to which we understand any information could differ. However, despite it differing from one person to another, one thing which is common is that the act of listening, cannot be undermined or overemphasized when it comes to its importance. Sometimes you may think, if I read this, if I just go into my cubicle and read this, I will understand it. That may be your thoughts. Sincerely, that may be your thought, and it could work. However, most times, the best place to learn is in a lecture hall. You can sacrifice any other time you want to do in a law school with any other thing you want to do. Participate in all activities. Trying to say, oh, I'm going to the law school to go and read, so that I'll come out to the first class, may not be actually the only way to get a first class. That may make you earn a first class, but that may not make you the best of the first class if you think that is the only way to go about it. Participation in all activities, both extracurricular, the externship, the court attachments, participating in all activities, combining it as well with what works for you in terms of reading could actually become the master stroke that will determine whether you graduate as an excellent student, a distinction student, or a very good student, or a good student, with respect, or a poor student. Because there must always be failure. No matter how you try, some persons must still fail. These persons may fail not because they do not know, but maybe because they misapplied the knowledge they knew in the manner the law school does not require. Instructions in examination hall are of utmost importance to how you are graded. You read your instructions, answer the first and any other 3. Answer these, and you do not rush and believe that the questions put forth to you are put forth for you to answer as much as you want and in the manner you so wish. Sometimes the instruction is the master stroke. Answer question 1 and any other 2. You refuse to answer question 1 and you proceed to answer any other 3. Maybe question 1 has 30 marks. And you proceed to answer the other 3, which you believe you know to the best of your knowledge. Sorry to say, that best of your knowledge may equally not even earn you the complete marks there. Hence, you're already struggling to pass the exam, even from failing to attend to the instruction. Because if you had maybe attempted to answer the first one, which was a mandatory question, your effort there may yield you some 10, 15 marks, while you go to struggle for the other marks from the other parts. But because you fail to accede to the instructions put on your question paper, the implication is that you are already heading towards struggling to pass and not struggling to get a distinction. Very important. While in the law school, the bar finals does not start on the bar final week. The bar final actually commences from the first day you step your feet into the law school campus. It continues even till the period you step out of the law school for your court externship and chamber externship. The reason is this. During our time, if I may recall, it was immediately upon returning from the externship that the MCQ examinations were conducted. I think it's applied in different ways for different sets. But usually, the MCQ questions are generated from what you should have observed or participated in during your court or chamber attachments. The MCQ questions have certain marks and threshold set for them. When you fail to get some good grades, it's like your CA, continuous assessment in universities and schools. The continuous assessment is what places you on the trajectory to victory. When you have a clog at the CA level, getting an A becomes more work, because it therefore means you must be impeccable in the examination hall. You must be impeccable in the examination hall. Now, being impeccable in the examination hall may not be impracticable or impossible. However, because of the culmination of multiple factors, including time, pressure, tension, and what have you, being impeccable on the examination day becomes more or less an exercise that may require God's grace. Having said all this, I will say this. The primary thing to pass the bar final and to excel in it, the immediate past speaker, Mr. Jibola, did say very correctly. What distinguishes the answer of Mr. A and B may not be. In fact, we had an interview for applicants into this firm very recently. I won't want to give too much of a breakdown of what we saw because it's quite terrifying. It was a bit terrifying and appalling. But one thing which, I don't know, some people may say I'm a wicked examiner. But one thing which distinguishes answers is the logic of your answer, the flow of your reasoning, and the distinction of your answer by the blending of those answers with provisions of the law and case laws. You know, from the university, when we were in the university, there was this way we were taught. They were telling us that if you can't remember the case law, just say in a decided case. In a decided case. Therefore, those who thought that those names were fictitious names, that they don't exist, or that lecturers don't know the names, they could just say Nabiola, Nabiola, Kafo and Okafo. They just mention names, believing that those names, in as much as you have mentioned a person's name, is already a case law. I'm sorry to say, the lecturers know the laws and case laws they are expecting. Because we have what is called, in every principle, there's usually a case referred to as a locus classicus. Those authorities are more or less like so common that it is expected that anybody who wants to distinguish himself in an examination hall should be able to mention those authorities. Mark Eke, FRN Abiola, Ibori and FRN. There are a lot of authorities in that classification. Non-mention of those authorities, and you go and mention a case that you think happened in your village, for the lecturer to think that those authorities exist. The lecturer will say, where is this man coming from? He will give you -1 first. He will not even give you a mark. He will rather minus the one you've scored elsewhere from that one that you have tried to deceive him, because that is called deceit. So very importantly, as I will say, what will distinguish you in your examination is not only the beautiful English you have spoken. Law is not English. Law language is not English language. Because even in speaking the law, sometimes you may blend it with legal jargons, maxims. And I think the more you use legal maxims in your write-ups, the more beautiful and the more enticing it is for your lecturer to give you more marks, even without reading through the end. If, for example, I'm reading to you and I'm already seeing equity aids the vigilant, not the indolence, in your reasoning, and the reasoning is flowing, I don't need to read to the end to know that you know what you're saying. I will give you the complete marks I need to give you and move ahead, because I have other scripts to mark. But if I'm reading your work, and your work from the first line to the second line, it's as boring as Jack. I cannot want to destroy my mental health by reading further. I will simply tell you that, okay, good one, good attempt. 2. Next script. So your answers in the examination hall should be enticing enough from the beginning. In fact, that answer you know, that question you know that you know so well, attempt that one first, so that you can attract the lecturer to your script. And when attempting it, your handwriting equally. Your handwriting equally is of great importance. You know, in the Court of Appeal and Supreme Court, the rules of court has provided the particular style documents should be prepared. The font size, the space, the paragraphing, etc. If, for example, because you want to you want to be very economical with your finances, a document that should be 35 pages, you now try to squeeze it in. After all, I'm speaking very good English, into 10, 15 pages. The Court of Appeal justices, the Supreme Court justices would not consider your process as competent, no matter how beautiful, how competent the arguments are. That is the same way your handwriting can destroy your beautiful answers in your answer scripts. It therefore means that if before now you do not have a handwriting that is readable, that any person could legibly see and read, I would advise you please take a lesson in handwriting as quick as possible. Your handwriting must not be so beautiful and romantic in nature. No. Your handwriting should be legible enough that any reasonable man could read and understand what you're trying to communicate. It is very, 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 very important. Because woe betide you that you have a very beautiful content, but the content cannot be read by a second person. It means you are not communicating. You are communicating to yourself. And an examiner must know that you are indeed communicating to him for him to grade you in the way he wishes to grade you. You're not writing for yourself, you're writing for others to read. And you will not be in the hall where they will be reviewing the exam scripts for you to come and start explaining what you were trying to write or what you wrote. So you must write it in a way that it is legible and clear enough that anybody at being the examiner would be able to read and appreciate what you have deposited in the scripts. I would like to say this very importantly. When you go for your court and chamber attachments, I use the word here, cross-fertilization of knowledge. It's actually very, very, very important. If we have, as I just heard that we have more than 5,000 persons who will be going to the law school. These 5,000 persons are not going to the same law school. They will not be taught by one lecturer. They will be taught by different lecturers. When you go for your court attachments as well, students from different campuses may converge in a particular court or chamber, as the word used. During that period, it is not a period to go into self-isolation. This is a period for group consolidation. Consolidation of your knowledge from the various campuses. That aspect of it is very, very important. The reason is why it's important is because the way they may have taught them in Yola may not be the same way they were taught in Abuja. And in those little details exists the distinction. Because at the end of the day, when they give you the question in exam hall, you won't say, no, in my Yola campus, we were not taught in this particular manner. You won't be explaining that in your scripts. The answer will be the answer expected of a person in Abuja, Bayelsa, Port Harcourt, Lagos, Kano, or Yola. So it therefore means that your knowledge is not a knowledge in isolation. It's a knowledge that should be communal with respect to the various campuses of the law school. As I said earlier, do not believe and do not be deceived to think that you must read for 12 hours to get a distinction in the bar final exam. That is not the truth. However, if you feel that you want to do that, it is equally not a problem. But don't go to the night or the eve before your exam. Try to crash yourself to learn what you have not been able to learn all through your stay in the law school. During our days, I think it's called TDB. I don't know if that is still the name, till daybreak. You'll be reading, and by 5 a.m., you go and take your breath and rush to the exam hall, thinking that all you have read through the night till 5 a.m. or 6 a.m., you go and deposit it in the exam hall. When you're not getting to the exam hall, you go to the back of your script and start scribbling. Let me pour out all what I've been able to store as fast as before it goes. I'm sorry for you. The bar final exams are not questions that are subjective. They are practical questions that are analytical. You need to put in your thinking cap. You have to be on your thinking cap to be able to answer those questions. So whether you go and deposit the answers at the back, what you've been able to store in your head at the back of the scripts, those answers may become answers for nothing if you're unable to appreciate and understand those principles and how to apply them. It therefore means, as I said earlier, understanding is key in the bar final exam. You may know all what you need to know, but if you do not understand, knowledge and understanding are two different things. You may be knowledgeable on a fact, but you may not be able to appreciate that fact in a more practical term. Hence, you need to combine these two things to be able to distinguish yourselves in the bar final exam. Please take out that word ultimate in bar final. When I was in law school, I think I had mentioned my campus earlier. Something very, very strange. You know, when they say that the law school usually keeps an ambulance by the side, or that they put medical people around the place to be able to attend to persons who fall under the tension of the exam. That actually happened practically in my own campus. I won't want to give too much details, but I know that a co-roommate, not my necessary room, but the next room, had a terrible mental health situation that he did not participate in the bar final exam. When I mean terrible, I don't mean very simple one. I mean a very complex mental situation. All because of bar final. It happened 2 days to the exam. He was rushed to the university teaching hospital. His mom was called. They had to take him for emergency specialist attention. And that was how he did not participate in the bar final. I don't know where he is currently or what has happened to him so far. That is one experience. So many other experiences exist. It therefore means Don't think or believe that you need to crash yourself to be able to crash the bar final. You don't need to. You need to do all that you have been doing so far that has brought you so far. The only time you need to up your game the more, because usually, and not the only time, you need to up your game at all times. However, when, for example, you feel that you were at this point initially, and you now need to take a step forward, you need to now add more efforts. In that regard, it is not an evil thing to do. It is appropriate that at every time of your life, you try to improve from where you were to a better place. So when you combine all these things together, I'm sure you will have a very beautiful experience at your various campuses. When you get to the law school, we have 5 courses, as earlier stated. None of these 5 courses should be undermined. Don't undermine any, and don't overemphasize any. All should be attended to as at when appropriate and based on your understanding of each of them. For that one you believe you do not understand too well, try to meet those who can aid you attend to it. And try to attend to those that needs to. When he asked the question as to the grading of the bar final, someone getting 4 A's and turning to get an F, I agree with Mr. Jibola that sometimes it will be by reason of certain circumstances beyond one's control. However, most times equally, it's as a result of undermining the importance of one for the others. You see one as very easy, and it's because it's not just professional ethics. It's nothing. It does not matter. I'll just go and read the rules. In trying to do that at the end of the day, you crash yourself in trying to crash the bar final. So do not undermine any exam. Give every exam its appropriate time and attention. That one you believe that you require more effort to be able to understand it, give it more time. That which you believe you understand very well, give it its time to continue to appreciate its content properly. Do not say, oh no, this one, leave it, it's nothing. I'm sure if you combine all these factors into your exam, all of you here and those participating online are quite actually lucky. Most of us did not have the benefit of some of this kind of information. Maybe if we had this nature of information, we may have done better or may have done worse. So, but I will say that you all are lucky, and I believe you all should be able to apply this knowledge you have garnered within this short time appropriately. I'm sure at the end of the day, you all will come out in flying colors in your bar finals. The bar finals, as I said again, is not ultimate. It is just one of the exams you pass through to become a legal practitioner in Nigeria. There are many other exams you will attend that could even be more complicated than that. So do not place your mind towards thinking or believing that at any time the bar final will be an ultimate exam. It is only one of your tests to become a legal practitioner. So I think I've been able to touch through some of the nitty-gritties with respect to the practical aspect of seeing through your bar final examination. As I said again, your MCQ, attempt as many questions as possible. Don't leave any unattended to. On the main exam, read your instructions, attend to the questions as instructed. If there's any question that has been placed as a mandatory question, please attempt that question. Attempt that question. Your attempt may yield you a better mark than any beautiful thing you go to write in another question. So I would plead and encourage us all to be very detailed in our following through with respect to instructions in examination hall. I don't want to mention the other one, but it needs to be mentioned. In all the beautiful things you've read, in all the beautiful preparations you may have made, do not allow yourself to become a scapegoat under the guise of examination malpractice. Scapegoats in the sense that you may not necessarily be the one who is copying or who is looking at an extra information somewhere. You may just be a conduit, a person who is being a good Samaritan, or a person who is trying to be generous, or a person who is trying to become overzealous. In all this, don't try to be any of this. You can be such an excellent student and be caught in the web of something you never planned or contemplated in your life. And I can assure you, if there's one environment that discipline is entrenched, the Council of Legal Education, the various campuses of the law school, is that environment. Try as much as you can not to fall prey or foul of any of those rules. For campuses where the biometrics are mandatory, I don't know if it's in all campuses now, try to have your biometrics done. I know sometimes well, try as much as you can. Try as much as you can to attend the lectures, to attend to the threshold of attendance required for you to participate in your exams. So that you on the day of the exam, you're not under any tension of whether you'll be allowed to write the exam. Because mentally, an examination is not just a physical, it's equally a mental thing. You must be mentally prepared, calm, and ready to see through the questions and answer them. I think at this juncture, I will be concluding this section. And I don't think this section, if there is any question, please, with respect to this section, because I believe this section was quite participatory and requires no further explanation. Please, if there is any, I'm up here ready to answer. No, he can't be asking. He can't be asking. So, okay, please, is there any contribution? Any contribution generally? Any contribution, please, yes.
All right, good afternoon, everyone. My name is Salaudin Ikmat Olongutola. So I'll keep it short. It's more of a recommendation. So why I appreciate Law Corridor for this wonderful initiation. Okay. Why I appreciate Law Corridor for this wonderful initiation and contribution to the society, I would simply like to recommend, as an advocate, SDJ advocate, I would simply like to recommend that in future session, we can include female speakers. Yes, this is not to demeaning the male speakers here. It was a wonderful session. So this is going to help in contributing towards SDG 5, ensuring gender equality. Thank you very much.
In fact, we will need to appoint a female partner tomorrow morning.
Some of them are currently in court, and that's why we have to use some other persons to participate on their behalf.
So hope we have scaled through the XDG number 5. So, but that is a good contribution. The firm, actually, let me now also add, the firm has more retinue of ladies than men. We have more ladies than men. So you put actually, the equality is actually even against us in this circumstance. You put actually more than us. So there's no equality here. So Please, we are a firm that recognizes all gender, and we are gender balanced. Thank you very much. All gender, that's two now. Yeah?
All right. Yes, comment.
Good afternoon again. My question goes like this. Regarding the handwriting, which you said is very important, it's fundamental. I think I had my coursemate when we were in university that in ABU's area. There is a friend I know that is good. We have had so many, we have had so many classes, like online and offline classes together. But during the exam, he always have an issue with handwriting. Because the guy is good, but when it comes to handwriting, he has so many issues. Sometimes when the result is out, he have carryovers. So he went and I think he met the exam officer, and then he was like, I think he almost challenged him, and then they brought out the script. Seriously, even him, he can't even read what he wrote. And then you said something about learning how to write, which, but you didn't recommend anything. Is there any platform that can help someone or anything? Yeah.
Thank you. I will say this. If you know you, sometimes when you know you have a writing that is not so legible, one of the easiest way to escape that problem is to write slowly and spaciously. Your wording should be a bit more bigger than the normal size of other person's writing. Because the more your size goes bigger, the more legible, no matter how difficult it would be. Because there's a time, they say, there's something you can't teach a 40-year-old man. What's that way they usually say it? There's a period when there are certain things you can learn at old age. One of them is the way you've been writing for a while. It's going to be extremely too difficult to alter it radically. You can only try to reduce how complicated it was, but you cannot make it perfect all of a sudden. So you cannot change it for bar final. It's not possible. What you can only do is to try to make it legible enough that a third party would be able to read it even without you being present at that place. So what he should do is let him try to make his writing a bit more bigger and more spacious. The more you write in that manner, no matter how your writing is terrible, if maybe it's possible, you could also write, please, I have a bad handwriting, please help read my script. please read my scripts. I have written very well. So please don't read carefully. So please, that's it, sir. Thank you very much, please.
Thank once you again, you have, this young lady for gender sensitivity.
Okay.
A lady raised her hand and I disqualify, I'm gone.
Okay, yes.
Thank you so much, sir. Good afternoon. Thank you so much for this platform. My name is Okele Adebusola Oreoluwa. My question is as it relates to the bar finals. So prior to now, a lot of us, we've probably seen different recommendations that before your bar final, you must have covered the syllabus like 5 times. You must have covered the syllabus before you go for your court externship. And at this point, we don't even know what to believe anymore. So I want to ask what you recommend, because if we're to go by what social media and tattoo tellers are telling, I feel like we might miss it. So I want to ask for your recommendation. Thank you.
No, wala. So let me say this.
Thank you.
Very good observation. Very good observation. Actually, that's why I started my discourse with saying that the word that what works for A may not work for B. Well, one thing is primary. Covering your syllables 5 times does not mean that you understood the syllables 5 times. That you read the syllables 5 times does not mean that you now understand that syllables 5 times. You could read the syllables for 5 times and you're referred to a particular chapter, even in chapter 1, and you do not understand it. So at the end of the day, what is more important, as I have said, is if you have read the syllables once and you understand the syllables once, you are better than that person who will read it for 10 times and not still understand it. So the aim and the most important thing there is understanding. To every effort you make a day, be sure that you have been able to understand that particular day's work before going to the next one. It is not how quick, it is how well. That you have read the syllabus 5 times is not a thing of joy. What is a thing of joy is that I understand 5 chapters of the topic. That's what is more of a joy, because if you understand 5 chapters, it means there's no way 3 questions will come from there and you will not be able to attempt them and attend them very well. So what is more important is understanding. It's not how quick you have been able to attend to it. Now, have I been able to attend to that? I want to now go back to what you asked when I was not here. I followed it through online. You said that you were taught, or you had some person say that litigation is now, what was the word? Liquidation. Thank you. As far as legal practice exists, it is impracticable. You know the word impossible. You say we should stop using it. We should rather use the word impracticable. You rather say we want to use the word impracticable. But I want to tell you, it is impossible that litigation will go into extinction. As the world evolves, so are crises evolving. The only thing that will evolve is the style of litigation, not litigation. And also to correct one thing which many young lawyers tend to want to get wrong. What area of law should I do? The area of law you should do, you should go and learn law. Go and learn law. When you learn law, you can now go and specialize in one sector. You cannot say from you're going into the law school and you're asking, well, I want to know the area of law I specialize in. You cannot be specializing when you have not known law yet. You must first know law before going to specialize. Okay, there's a camera. Oh, sorry, please. I thought I was interacting with everyone here. So very importantly, you must know law. You don't from you have to go to the law school and you're already saying they want to go and specialize in corporate. No, you cannot be talking about that. If you do not know law, when you get to the corporate, you'll be stuck. You'll be half-baked. You must first know law before going to the next stage of appreciating a particular specialization. So thank you very much.
A wonderful round of applause.
Can I introduce myself?
We'll be introducing everybody. Let's introduce you.
Okay, that's fine.
Let's do you the honors. Yes. Having heard from the managing partner, Mr. Henry Kelechiku Eni Otu, one more time a round of applause for him. We wouldn't close this session without hearing from the bigger elephant. In the big fish, the shark in the ocean.
An elephant
the very loved, cheered, admired, handsome Mr. Pelumi Olache, Senior Partner Law Corridor. He'd like to have a word with you guys. The floor is actually open for general discussion now, and Mr. Pelumi is going to start that for us. Once he's done, we'll pass the mic round for other associates of the firm, attendees to also have 1 or 2 general remarks. Thank you very much. Mr. Pelumi, on to you.
All right, good afternoon. I'm sure it's afternoon. Please indulge my voice. I'm going through a lot. I'm sure I'll be able to pass very, very important information that you can find interesting. Now, I'm not here to do any presentation, but I just think I should speak to a few persons here who can find my contribution useful. For those who are going to law school, now it is important for you to understand that going to law school is a pathway for you to fulfill a career progression. Already, having studied law in university, it is believed that in equity you're a lawyer. I mean, but what you want to do in law school is to understand the procedural way of practicing law. So how you prepare for law school is dependent on what you want to get from law school. How you prepare for law school is dependent on what you want to become in life. I will advise that if you don't have the convincing vision to become a lawyer and a lawyer who actually want to practice, you don't have to kill yourself in law school. You just go there, you pass. Some people even study law and they don't have to go to law school. The difference between the person who has graduated from law school and the person who is just a law graduate is the fact that you want to practice law. So now you need to design what you're doing in line with your aspiration, in line with your vision in life. Time is very important in everything you do. If you're going to law school for about 1 year and you're going to invest that 1 year in law school just because you want to please anyone, and you still have maybe a particular career path you want to pursue, it is important for you that even while you're in law school, you can invest your time in any other venture you're interested in. If you will graduate from law school and you end up winning a fashion, is it fashion shop or what do you call it, or salon. But if you will go to law school and you actually want to practice law, then you must take law school seriously, number one. You must be very, very serious about law school. I noticed that Mr. Henry was trying to de-escalate the perception of people being scared about going to law school. If getting scared will make you prepare for law school very well, I think you should get scared and prepare for law school. It is good for you to do it excellently well and you come out well. People who prepare for law school very well and they commit themselves to it, oftentimes come out very well. So I would advise you, the first thing you need to do is that get prepared for law school. Now, how do you get prepared for law school? It's actually straightforward. There's no rocket science about what you're being taught in law school or what you'll be taught in law school. You need to understand your courses and you need to study them very well. You need to expose yourself to study groups. You need to study your professional ethics very well. As a matter of fact, it will be an impossibility for you to write any exam in law school without questions on professional ethics, even without writing the professional ethics exams itself. So, let me quickly say this. By the time you go to law school, you graduate from law school, you become a lawyer. You need to understand that there's this, for those who want to become lawyers as professional, there's this high tendency that you actually want to work in a law firm. I want you to know today, even though Nigeria is not producing enough lawyers to be able to service the crisis we have in the country and the need for legal services, to engage lawyers and pay lawyers very well. Now, this is the point. There's high competition out there for law students or lawyers after law school to get recruited in law firms that are very, very serious. And you see, you have maybe over 1,000 law firms in Nigeria, but law firms that are very, very serious are not up to 100. What I mean by law firms that are very serious, not being up to 100, law firms that can actually assist your career to go, law firms that can expose you to proper training, law firms that have depth of knowledge, and law firms that can pay you well. And so there's high level of competition. Here in this firm, we don't employ anyone less than first class. If you are getting into this firm, you don't have first class, maybe through a native doctor, or you have someone somewhere who knows someone, or probably you've done extraordinarily well, probably during test, examination, interviews, and all of that. And there are also top firms like that. So if you want to graduate from law school, and you really need to work well and grow in your legal career where you'll be paid well, then number one, you have to graduate in first class. But if you don't graduate in first class, you can graduate with second class. But if you are not even graduating with first and second, just make sure you graduate, because it can be it can be emotionally traumatizing for you to go back to law school. When I was in law school, I didn't just want to come back to write any paper. It's not because I have anything against people coming back to write anything, but I can't withstand the stress. I graduated from, by the way, Lagos campus, the best campus ever. And yes, are you guys clapping or you? So I want to advise you that it will be in your interest. Today, lawyers or no lawyers, Nigeria is producing over 1 million graduates every year. Monotechnic, polytechnic inclusive. And Nigeria does not have capacity to employ 100,000 every year.
That's not it. The real life starts after law school, to be honest. The real struggle begins after law school. What you face in law school is just a very small phase where you write 5 courses, then one MCQ, and you come out. But then, that's not to take your mind away from the serious approach you have to give to law school. And it's also not to scare you anyways. But then, the way the law school work is that you already have 100 marks on each course with law school. It's you that will determine how many they want to remove. So in each course, you have 100 marks with law school. So if you are serious enough, they can deduct 70 and you come back to write receipt. Or if you're serious enough, you get 70 and you come out with your first class and all of that. But then again, after the law school, the grades you come out with do not also define you. It may be very important to get into a good firm and all of that, but it doesn't define you at all, define who you are. So all of this advice you've gotten today and everything, you have to apply them in your studies, the way you do your things when you get to law school. And don't be distracted. But the first thing you have to do in all of this is to know yourself. If you know within yourself that the background is bad, or the foundation is bad, and the righteous cannot do anything, you have to sit down again, address that foundation before you now wait for the righteous to do anything. That's the first step. Know yourself. If you know that you have to read for 5 hours every day to get a particular point, please read 5 hours every day. If you know that you have to read 2 hours every day, please. But then if you religiously read for 30 minutes per day from the day you get into law school and you attend all the classes and you do all the pre-class tasks, it is impossible for you to fail law school unless your village people are after you. Do you understand that point? If you read for 30 minutes per day and attend all the classes and then you do all the pre-class, it is not possible for you to fail. I, for myself, I only visited the library 2 times. First, when I became SRC chairman. Second, 1 week to exam, they said that there was no light in the library, so I had to go and confirm. I didn't go to the library for any reason. I didn't also go to other places to go and no, I never did that. So just, once you attend those classes and you read properly, you're going to pass. Look, it's not that deep. You can still enjoy life when you're even in law school and still pass. Thank you very much.
Yeah, before I take another comment, who's available to give us any further comment? Blessing? Okay. Now, before I call Blessing, I'd like to recognize the presence of Mr. Stanley Alieke, the managing partner of Law Capital. A round of applause is somewhere in the corner there. There's one quote I like to give before this passes me by. Just one quote I like to give. It's a quote we probably would have heard in our 100 level, in our philosophy class, by Socrates. Man, know thyself. So whatever you've seen on social media, whatever you've heard here today, from me, from Mr. Henry, from Mr. Palumi, from Kamar, from anybody else that you would hear, it all depends on how you know yourself and determining what best applies to you. The reading. My uncle will tell me the brain is like categories of foam. If you drop it in water, there's the one you drop in the water and it will absorb water almost immediately. There's one you drop in the water and then you apply some pressure, a little pressure, and then it will absorb water. There's the one you keep tapping for a long time before it will absorb water. So different things will apply to different persons. The question is you knowing where you fall to determine whether or not you need to read, like you asked the question, whether you need to read the syllabus twice or once. Once you know yourself, you analyze yourself, introspect, and determine what best works for you and simplify the pattern, right? So it's true, some people, they went to Lovito, they had fun in law school, and they still passed at first class. Some stayed in the hostel. Lovito used to be opposite Abuja campus. It's a club. On Friday, you'll be hearing Davido back then. That was the raining song. You'll be hearing it on campus. Students, my classmates, they'll be there dancing. Some of them passed, some of them failed. Some of us that didn't go, some of us passed, some of us failed. So different strokes for different folks. With that blessing, can we have comment from you?
Good afternoon, everybody. My name is Emeka Blessing. I'm an associate with Law Corridor. So we've heard a lot today, and I'm sure that some of us would have loved to have this information before we went to the Nigerian Law School. But by the grace of Almighty God, we came out successful as well. I'm going to be touching a few things that was not mentioned. Some of them were already flogged by the head associates and our managing partner. For one, take your health seriously. Some people go to the Nigerian Law School and they gas themselves out every night, doing till daybreak. Why? And then on the bar final day, you are sick. You are fainting on the exam hall. They are rushing you with the ambulance. Is that really necessary? Is that why you're there? So take your health seriously. Make out time to eat good food. Sleep at night. You will pass. I assure you, you will pass. Once you do the work you need to do, everything is covered. Secondly, manage your time properly. You know, some people know a lot, and you want to give law school an assignment to mark your script. I assure you, they will not read it. So manage each and every time you have. Allocate proper time for each and every answer you're about to take. If you're answering number one, say, 30 minutes max, I'm done with this question, and you move on. In your MCQ, have it at the back of your mind that, at least I should have like 30 seconds to answer one question, and I'll move on. If you cannot align with proper time management, you will have so much answers in your head, and you come out, you realize you answered company law, you answered civil litigation, but you are getting 0 in criminal litigation and other courses for your MCQ, and you don't want that. The next one is, there was something that happened when I was on campus during my set. We wrote our corporate company law, and then immediately we came out, everybody was like, did you see number one question? What did you answer? Oh my God, I'm going to fail. Oh my God, what is happening? There was panic. And they started marking their scripts as if they were the law school professors. And that is not something you're supposed to do. Once you write your exam, have it at the back of your mind that you've done your best in this course. Move on from it and go to the next one. Prepare for the next course. Just leave it as is that. If you cannot leave it, you kneel down and say, God, help me. And then you move on. Don't mark your script for law school. Don't worry. They will mark it and you will favor you. That's my contribution. Thank you.
Thank you so much. Sorry, yeah. You want to add something to that?
No, it's not correction. So, please, I just want to endorse what Blessing just said. Veronica, where are you? Come and sit there. So, please, I want to advise those of you, there are some of us who are somehow lazy, and we are after people we perceive as serious. We'll try to follow them up to see what they are doing and all of that. It's not everybody that is sitting down that is reading, that is understanding. No. Just calm down, prepare yourself and write your exams and be good. I want to tell you this quick story. While I was in law school, I'm an enjoyment person. I'm always everywhere. You know, I'm in class, but I'm also outside. We're outside. So, but I'm a very studious person, and I learn very, very fast. And I have that grace. I can forget later, but but if I don't want to forget, I won't forget anyway. So while we're in law school, my 2 friends, they are both first-class students from Afebaola. I won't mention their names. Some people know them. Brilliant guys. Like, they are all over. They are everywhere. They are the one assisting the lecturer, and they are the good people in school. And every night, they will read it the following morning. So when we started our exam, I think it was MCQ, and we did corporate law. And after the corporate law, I met them in their room. They were arguing about answers. And I was imagining what kind of, I was not thinking that could it be that, because there are some answers that you don't need to read about it. You understand? If you understand law, you don't need to read to know this is the answer. So they were arguing, saying a lot of things, and what was going on? And I told the two of them, no, that's wrong. This is the answer. They said, no, 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 no. So for me, I left after that MCQ. I went to town to enjoy. They started reading for the next exam. So after our exams, after everything, they came to Abuja to meet me. Because I'm based in Abuja. We were preparing to get our results. So they were in my house the day Nigerian law school result came out. So not until now, in the past, people are always scared of law school result too. I was even scared myself. So the first person who checked his results took him almost like 1 hour to be able to come up with the courage to check this. And after which he checked, he saw pass. Pass, first class student pass. Became drama. He was like, no, no, no. And maybe they didn't compute it well. Or maybe it's for one particular course. He wants to check again. Eventually he saw it was pass again. Then I said, if you can have pass. My own is not even fail. My own, I'll be owing a lot of marks. So, but I knew very well that the questions they asked us during bar final were straightforward, simple, and all of that. Again, the second person checked his result. It was pass again. The second first class student who was reading very well, pass. These are like life friends. As I'm speaking like this, they are watching this video, they know already. But I won't mention their name just to protect their dignity. But you see, the third person. Now, let me tell you about this third person. The third person is not just a first-class product. He is a very, very religious person. He was always praying. I won't mention his church, but he took me to church like twice. I left because he can't be doing church in the morning, afternoon, and night. So, but the day after the two guys checked their result, it was the third person to check. I don't even have exam number, so I can't check I don't know how to trace my result. The third person checked his result. He checked it, and it was, he failed. Did I mention it to you? So he checked it the second time. He saw that he failed. Now, I'm scared. But look, someone just called from somewhere. Have you seen your result? Congratulations. That was massive. That was... Where is the result? Send it to me. They text it to me. I say, okay, that's fine. I will continue our faji for the night. The point is this. Those guys actually very, very... When people are too brilliant at times, they start reading another thing. You won't understand what they are reading. The lecturer will be saying this. They'll be thinking about another thing. So I want to advise you. Do your work diligently, but do not be misguided by, especially when you're done with your exams. Don't panic about the exams that are coming. If you have done well, you will pass. If it's not good enough, you have a second shot at it, and God will help you. Thank you.
Anybody else? Anything to add? I think we've had a very productive gathering. This is just to say we wish you the very best as you proceed to the law school. Enjoy yourself. Be positive-minded. Look forward to a wonderful time at the law school. Ensure that you don't overpressurize yourself. Like I said again, know yourself more than anybody else. Have friends, make friends, network. Mr. Franklin said that already. Don't be over apprehensive of the exam. Don't run your clock by other people's timer. Don't decide what's good for you by what other people say is good for them. Understand what's working and what's not working for you. And don't forget that law school isn't the end. It's only a path to a new phase and a new beginning. We would close by saying thank you for coming for those who joined us physically here. And we'll also say thank you to all those who joined us virtually. The video for this session is going to be available on YouTube, so you can go to our channel to watch the video all over again. If in the course of watching the video you still have questions, you can drop it in the comments. I'm sure our media team will get the questions across to us, and one way or the other we'll be able to, respond to your query, questions, and anything you might have to know about. So on that note, we'll wrap up the day. And once again, to the crew, the production team, Mr. Samuel Olajengbesi, Mr. Victor, Mr. Shemilore, Ms. Kende, Ali Imam, the managing partner, the senior partner, Mr. Belumi Olajengbesi, Mr. Franklin, everyone who contributed, I want to say a very, very big thank you, and see you at the 2.0. Bye.